So there's been an important development in the lawsuits which aim to remove a state ban on the purchase and possession of suppressors. So let's talk about this. But real quick before we jump into this video, if you think suppressor bans are clearly unconstitutional, go ahead and hit that like button and subscribe. We are currently doing channel memberships for the channel. It's something that's been in the works for a while. A lot of you guys have been asking me how you can support the channel, and becoming a channel member is one of those ways. You can do that by clicking the join button down below. It's often by the subscribe button, so it's right next to the subscribe button. It says join. And if you become a channel member, you will get exclusive content as well as exclusive emojis, an exclusive badge, and just things that help me identify that you are a channel member, and it helps me to engage with you better. So if you're interested, consider becoming a channel member. But regardless, thank you guys so much for all of your support. As I mentioned in the intro, in this video, we will be discussing two lawsuits which aim to remove a state ban on the purchase and possession of suppressors. The cases we will be talking about in this video are called Morse v. Raoul, and then also Anderson v. Raoul. These two lawsuits are filed in a federal district courts, two different federal district courts in the state of Illinois, and they aim to remove the state of Illinois' ban on the purchase and possession of suppressors. These lawsuits are very important because although 42 states allow for the ownership of suppressors, they allow for the purchase and possession of them, there are 9 jurisdictions within the US which do not. These lawsuits could be the first in the nation which actually find that a state's outright ban on NFA items like suppressors is clearly unconstitutional under the Second Amendment, under the Supreme Court's ruling in Heller, and also the Supreme Court's ruling in Bruin. The Anderson case had prior been put on hold until Judge McGlynn ruled in the Illinois assault weapon ban and magazine ban cases called Barnett and some of the other ones. Well, as many of you know, Judge McGlynn recently did issue a decision which granted a preliminary injunction against the PIC Act, which that was the state of Illinois' ban on so-called assault weapons. But since that decision was issued by Judge McGlynn, these two suppressor lawsuits are now moving forward. And also there's an interesting update where both of these cases have now been consolidated under one specific judge under one court, and they've been consolidated under Judge David Duggan. Now, originally in the Anderson lawsuit, in their complaint, the plaintiff stated that the suppressors at issue in this case are bearable arms in common use for lawful purposes that law-abiding people possess by the millions. They are therefore neither dangerous nor unusual and cannot be banned. This is important because it's well established now that modern arms are in fact protected under the text of the Second Amendment, and the type of arms that are protected are not just muskets, like you like to hear the anti-gun side likes to argue all the time that they only apply to weapons like muskets. And simply in the legal world, that type of argument is absolutely irrelevant and has zero legal strength. In fact, the Supreme Court reiterated that fact recently in Bruin. The Supreme Court stated that we have already recognized in Heller at least one way in which the Second Amendment's historically fixed meaning applies to new circumstances. Its reference to arms does not apply only to those arms in existence in the 18th century. Just as the First Amendment protects modern forms of communication and the Fourth Amendment applies to modern forms of search, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. So that argument that suppressors are not protected since they did not exist at the time of the founding is absolutely irrelevant. Also, the plaintiffs in both of these cases argued that suppressors are not dangerous and unusual, and that the mere ownership of a suppressor cannot constitute the ownership of a dangerous and unusual item. Instead, these are common arms owned by law-abiding people for lawful purposes, and that falls squarely within the Heller decision. The plaintiffs in Anderson pointed out in their complaint that plaintiffs are law-abiding, peaceable citizens of Illinois and the United States who wish to possess suppressors banned by Illinois, and therefore they argue that under Heller and Bruin, a state like Illinois cannot completely ban the keeping and bearing of suppressors, which are common arms owned by law-abiding people for lawful purposes, including self-defense. Illinois is completely banning the use and possession of these protected arms, which again, at a federal level is legal. It's illegal at a federal level to purchase and to possess these items, but the state of Illinois is going even further and is having an outright state ban on these items. And through these lawsuits, the plaintiffs are asking for the court to find that a suppressor ban here in the state of Illinois is a violation of the Second Amendment. Now, originally, Judge McGlynn was also reviewing the Anderson suppressor case, which was before him, and he also stayed that for 90 days because of other lawsuits that were in front of him, including the Barnett case and some of those other cases which dealt with the state of Illinois' ban on so-called assault weapons. Recently, Judge McGlynn ruled in those challenges, and he found that the PIC Act there, that's the Illinois ban, the regulations there within and the regulations on accessories like magazines and flash hiders and pistol grips and pistol braces did in fact implicate the restriction on arms, which are protected by the Second Amendment. And ultimately, he found that that type of restriction is unconstitutional. So he granted a preliminary injunction in favor of the plaintiffs against the state of Illinois in that ban on so-called assault weapons. In that specific decision, he stated that this court will first address defendants' contention that non-essential accessories are not within the scope of the Second Amendment's plain text. The PICA outlaws possession of a semi-automatic pistol with a detachable magazine if it is equipped with any of the following: a threaded barrel, a shroud attached to the barrel, or that partially or completely encircles the barrel, a flash suppressor, or arm brace. Defendants contend that such items are not necessary to the functioning of a firearm and are thus not arms and therefore not protected by the Second Amendment. Defendant's argument is not persuasive. Then he concluded that decision by saying that therefore, because the meaningful exercise of the right of armed self-defense is wholly dependent on the ability of citizens to utilize their arms and hit their intended target, items that aid in accuracy may be considered arms and are presumptively protected by the Second Amendment. And after he made that specific ruling, the Anderson Suppressor lawsuit, which was on hold for that decision, was then removed from its holding pattern and is now proceeding forward. Then what interestingly happened in these cases is that the plaintiffs in the Anderson case asked Judge McGlynn and then also asked Judge Duggan in the Morse lawsuit to have the two cases consolidated under the one judge, which is going to be Judge Duggan. Now you may ask yourself, why did the Anderson plaintiffs want to move the case from Judge McGlynn to this other judge, especially when Judge McGlynn just issued a favorable ruling? And really, I did some asking around. I asked some of the attorneys in question, and they ultimately said that the belief is that Judge Duggan is even more pro-2A than Judge McGlynn. It appears that yes, Judge McGlynn issued a favorable ruling, but that Judge Duggan is potentially even better. So the Anderson plaintiffs asked for the cases to be consolidated, and Judge Duggan and Judge McGlynn agreed that the two cases needed to be consolidated, and they're moving forward under the one judge, which is going to be Judge Duggan. So now these two challenges to the Illinois state ban on suppressors are moving forward under one judge. And really, I think that will help in some ways because now you'll have all the resources of all the multiple groups and multiple attorneys, pro-2A attorneys, kind of going forward in one courtroom in one specific case under one judge. And all indications are that this one judge that these cases are consolidated under is a more pro-2A friendly judge. However, that's yet to be seen. And if we get any more information, if anything else develops, I will let you all know. But this is an important lawsuit, not just for the state of Illinois, but really a lot of states that have bans on NFA items like suppressors, and that includes even states like California, which I live under. So again, if we get any more information, I'll let you all know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.